think you heard the judge just now, the decision. The decision is that since since Maria Chin has already been released, and we had our main remedy was for her to be released. Therefore, he does not want to decide on the question of whether or not the arrest and detention was lawful or not in the first place. We had argued that based on very high authority for the federal court, this court should actually continue to hear the case because this is a matter of public law in the public interest. And it is, to quote the AG himself when he was a Court of Appeal judge, this is a burning issue which the nation wants to have resolved. Already, the Chief Justice, Arifin Zakaria, is on record as saying that 110 cases were decided on SOSMA in 2015. Now, this is a very new law, and the ambit of this, the scope of this, should be adjudicated by the court. And this was a perfect opportunity for the court to do so. But the court, in its own wisdom, has decided that it will not go into this matter. So we have no option but to take this matter up on appeal so that the higher court then can look into this matter a little more closely to try to establish the parameters of this new act, which the second respondent in this case, IGP, has already threatened will be used more and more. So I think in a country that is governed by rule of law, we must have clear legal parameters, all right, based on the federal constitution, based on the law itself. We cannot allow an unfettered discretion to remain in the hands of the policing authorities alone, because we have the courts, we have the judiciary, we have the courts, we have the executive, we have the legislative. There must be checks and balances. That is the meaning of the rule of law. For this reason, our client has instructed us, Maria Chin Abdullah, to pursue this through an appeal. Thank you.
One of the points made actually was that the AG's chambers had not filed an affidavit in reply. Now, so what is unsatisfactory, as far as I'm concerned, is that there has been no accountability as to why Maria was treated in the way that she was under SOSMA. And I think that is something that we would explore in the Court of Appeal, since we now have instructions to file that.
There is also something that I would like to add.
Yeah.
The reason why we also say that it is a live issue, if you look at the raid that happened yesterday in the Empower's office, the police officers actually informed us, the lawyers who were present, that they were also investigating Empower under Section 124C of the Penal Code, the exact same section. And they also informed us that they're using SOSMA provisions. So this is definitely a live issue, and there are definitely more cases coming up. So the judge should have exercised his discretion, and he should have heard the case.
I think that we really owe the public an explanation on this whole SOSMA. It's not just about me, my case. Now we see that, you know, it's affecting Empower. And is it going to be extended to other NGOs, other individuals? We have to know, is the detention legal or illegal? That is a question, that is a national question that we have to answer. Because if you remember, when Najib became the Prime Minister, he promised that he will get rid of the ISA. He did, but he replaced that with SOSMA, which is the same provision as the Internal Security Act. No counsel, no access to your family, and you can be detained up to 28 days. So I think that, you know, not only for myself, but the general public must know, you know, why do you have to use SOSMA, and how do you define terrorism? You cannot, I mean, civil society, we have done our role in terms of being the check and balance. We actually ask questions. And what are the questions that we have been asking? Free and fair elections. Does that warrant SOSMA to be used against us? You know, I don't think so, seriously. Any other questions?
Yeah.
Yeah.
Is there possibility that you file a writ of summons instead of
Yeah. Well, of course there are other avenues, but the difference between Teresa Cox's case and Maria Chin's case is, in this case, while she was in detention, we filed. And then she was released. So this is more like Azam's case, which we quoted to the court just now, to the judge, where he was released. When the case came up for hearing, he was already released. Right? So should you continue with the case or not? Yes, if it is a matter of public law in the public interest. But we, of course, will reserve our options, because at the end of the day, we want, as Ambiga has said, we want accountability. So there must be accountability. And, you know, the point is that they just didn't reply to the affidavit. To all our allegations, they didn't reply. And the judge used that as a ground for saying, because of that, he cannot decide the case. Yeah. It's a circuitous argument. It is an argument which, in his wisdom, he feels he's right. But it requires a bit of explanation, I think. No, that is what would have happened if the judge had continued to hear the case, because we are challenging all the sections I mentioned. You know, SOSMA, you know, they say you cannot arrest a person for political belief. Okay, what is the meaning? Was she arrested on the basis of political belief? So what is the criteria to decide political belief or not? All right. Then they say this section 124C of the undermining parliamentary democracy. Right. What is the parameters of that? That's what we raised just now. It says only by violent means. You can quote Hansard. You know, Nazri said that it applies to situations where you're actually going to overthrow a system, right? Not when you are challenging when you say that, you know, you have misgivings about the way governance is carried out, by the way elections are carried out. That is not the intention of 124C. It's an offense against the state, against the system of the state, by violent means. We saw the rally, Bersih rally, was as peaceful as can get. In fact, I think it was too peaceful, right? So people are wandering around not knowing what to do in some places, right? So can that warrant this? And also, if you look at which we wanted to raise, we'll give you after the grounds of our main application. After this, you just collected from us. But one of the grounds that why they needed 28 days, they couldn't do it in 2 days. They said, because they need to photograph Maria Chin. They need to take her application. They need to get password for the computers. They need to, secara terperinci, go and check the accounts with the banks and so on and so forth. I mean, for this you don't need to put Maria Chin Abdullah in 28 days detention under SOSMA. That is why Supt Tham said it is a misuse and abuse. So we wanted to have this clarified instead of people, even governmental authorities, statutory body like Supt Tham saying the misuse and abuse. We say, let the court decide. Let not other people say, this is abuse, the IGP is acting badly, and so on. We don't want all that. We want the court to make a legal pronouncement on the ambit and then to decide whether or not it was proper or not proper for Maria Chin and people in her situation to be detained for these reasons.
Yeah. And I would also add, I hope Maria doesn't mind me saying this, but Maria has been very clear that because of her case and because of so many other, not so much because of her case, but because so many people are affected by SOSMA and likely to be affected, that we must vigorously pursue a course of action to challenge SOSMA. That is very clear from what Maria has told me, that we must challenge SOSMA. That's Maria's stand. Okay. Am I right, Maria?
Yes.
Okay.
Were there any conditions attached to Maria's release yesterday?
Yeah. Any conditions?
No conditions.
No conditions. No conditions.
Save to be available for further questioning if necessary. Yeah. That's not a condition.
The country anyway.
Yeah, I can't leave the country anyway.
Travel ban.
Further questioning, further investigation?
No, we don't. I think we don't know.
We don't know whether there will be or not. Yeah.
They didn't say whether there will be.
No.